It has never been mentioned as to how that clarification was.
That's the point. This is the
Yes.
witness who's going to clarify. The
May
court is in the dark like me.
May I address the court?
Yeah.
There was no, in the application itself, it was not stated as to how such clarification was going to be elicited in this court, either orally or in terms of documentation.
That's right. It was
So
never-
now we are finished with more than 20 documents,
Yeah.
more than 15 pages.
Yeah.
We haven't consulted with our clients.
Yeah, not quite.
And my
That's
lord-
a fair comment.
I've requested that the state, in seeking this clarity, will it not invite new evidence? But looking at the papers that were given, it shows that there's something new that will crop up.
Hello?
Something new that will crop up here.
I don't know.
That's what I foresee.
You're a prophet.
I'm a prophet.
Yeah. You foresee
I'm a
this.
legal expert.
No. I'm not being cynical.
No,
You
I'm
say
a-
this is what you foresee.
That's what I foresee.
If you foresee something,
Yes.
yeah.
From the look of things, my lord, look, my lord, let us be genuine. If I'm saying the state, you know, there's something that I'm concerned about. The state brought an application, we didn't oppose it.
We are fine.
Not that we're doing the state a favor for not opposing it. But the state should be transparent enough to the defense. They should tell us in their application that we intend to clarify this part of evidence by tendering certain documents in order for us to clarify the concern that each party has. But this now, the state, as it always the position, they like to take us by surprises. They always take us by surprises. We don't want to listen to this evidence until we are satisfied with this document.
Is that how a lawyer speaks? You don't want to listen to this evidence.
Of this witness.
You don't want to.
We don't want to listen to it before we get into knowing what is in these documents.
But Mr. Baloy says he explained.
But my lord, is it genuine enough or fair
I don't
enough?
know. I don't
no,
know.
But this is what I'm submitting to the court. You bring an application. You say you sought to clarity on this part of, but you don't state that this clarity will be expressed in the form of oral evidence or documentary evidence. Now you give us documents, then you want to lead evidence. That's not fair for the defense. That's not fair for the accused. Every time we need to succumb to all the requests that the state is making.
Sir, are you available tomorrow?
Yes, available tomorrow, but then going back on Thursday,
Oh, sorry about that. Tomorrow is what? Wednesday?
Wednesday.
What time are you going away on Wednesday?
On Thursday, 11 o'clock.
In the morning.
Yes, sir.
The court is prepared that you should study the documents that you say you want to study them. How long do you need for that? This witness, I can prevail on him to come on Monday next week, so that nobody says we were taken by ambush. Are you available next week, Monday?
I'm available, but you must keep in mind it's a long weekend.
I know. Oh, no, the weekend starts on Friday.
Yeah, but to get back to Joseph,
Oh, you'll be back on what? Where?
in the Western Cape, in George.
Yeah, in George. But I'm saying on Monday. Is it the holidays?
No, it's Friday's holiday.
Yeah, Friday. No, I'm saying
So if there's a plane available, I'm available.
on Monday.
Yes.
Yeah, this court is preparing to postpone the case on Monday to Monday next week. And then I can postpone it for you to be apprised of the documentation, because this witness says, I don't want to say, they say I'm putting words into your mouth. Is that the clarification documents you're going to use?
That's correct, yes.
Those documents are in clarification
That's correct.
of your evidence which you led here.
That's correct.
Right. Okay.
May I request something, my lord? I'm not speaking on behalf of all the defense, but that's my request. I'd request the same exercise that was done by
The what?
General Colonel Khosi when he filed a supplementary affidavit. I request that his clarification in my own request, that such clarification be also reduced into writing. To be reduced into writing in a form of an affidavit.
You are prepared to do that?
And incorporate all these documents.
I can do it, man.
And when can you bring that clarification? Because if you do it in the form of an affidavit, are you saying he must also come to court? You must have
Mr.
it.
Host
Wait,
did
wait,
come
wait.
to
No,
court.
I'm not talking about Mr. Host.
No.
I'm not talking about Mr. Host. I'm talking about this gentleman.
He must also come to court.
If he does it in an affidavit,
He must also
he
come.
must also come to court. Are you
Correct.
saying you'll do that?
Yes.
Okay. Right? How many days do you need for his affidavit? 2 weeks, 2 years?
My Lord, on my side, I just need overnight to go through the documents. We can proceed tomorrow on my side.
Yeah, no. On your side, how
I
many?
also need it overnight.
And then the witness must come on
Okay.
Thursday.
Tomorrow, it's Wednesday.
Yeah.
It can
And then the
come
witness
tomorrow.
must come on Wednesday. Thursday he says he's not available.
Tomorrow.
Yeah, he
Tomorrow,
says he's got to be back home on Thursday.
Tomorrow the witness is available.
You know, I quoted you guys a case which says litigants should not make it impractical for a case to go on. I want to quote it again. Yeah. Yes. Where's that judgment of the Director of Public Prosecutions versus, I don't know. Somebody takes my cases here. Maybe it's still here. Oh, here it is. Let me quote you what these guys say, not me. 5 judges of the High Court, of the of the Supreme Court. It's Harams, who was the Deputy Judge President. Malan, who used to be my colleague in Joburg. Mlambo, who is now my JP. Nugent, and Majid, who's now in the, Majid is in the Constitutional Court. Nugent is retired. He was an SCA judge. Lambo is still around. Malan is retired. Harams is retired. It's 1, 2, 3, 4, 5 judges. It's not me saying that. 5 judges of the SCA. You may be seated, sir. Because we gaan nie getuig vandag. Fairness. This is the case of National Director of Public Prosecution versus King, 2010, number 3 volume, All South Africa, page 304, South African SCA, Supreme Court of Appeals. This judgment was delivered on the 8th of March 2010. And this is what it says, amongst other things. It is well, that's paragraph 41, paragraph 4 of page 315. And this was a unanimous decision. There was no dissenting decision. 5 judges agreeing. It is well to remind Just to give it a bit of context, let's start it at paragraph 3. Paragraph 2, the blanket privilege, meaning the submission or the privilege of granting documents in terms of State versus Chabalala, which is a constitutional court case. The blanket privilege has not been replaced by a blanket right to every bit of information in the heads of the prosecution. Litigation privilege does still exist, also in criminal cases, albeit in an attenuated form as a result of these limitations. Litigation privilege is in essence concerned with what is sometimes called work products, and consists of documents that are by their very nature irrelevant because they do not compromise evidence or information relevant to the prosecution or defense. This much is hardly contentious. What is in contention in this appeal is whether an accused is entitled as of right to a full description of each and every document to which he is denied access, all being documents falling within parts B and C of the docket, with a statement of the precise basis upon which access is denied to any document in order to have a fair trial. In other words, is the accused entitled to a motivated index to satisfy him in advance that a trial will be fair? The court below held in the affirmative, and hence this appeal of the National Director of Public Prosecution. It is well to remind oneself at the outset of a number of basic principles in approaching the matter. Constitutions call for a generous interpretation in order to give effect to the fundamental rights and freedoms that they create. The right to a fair trial is by virtue of the introductory words of Section 35(3) of the Bill of Rights, broader than those rights specifically conferred by the fair trial guarantee therein, and embrace a concept of substantive fairness that is not to be equated with what might have passed muster in the past. This does not mean that all existing principles of law have to be jettisoned, nor does it mean that one can attach to the concept of a fair trial any meaning whatsoever one wishes it to mean. The question remains whether the right asserted is a right that is reasonably required for a fair trial. A generous approach is called for. A generous approach is called for. This is a question for the trial judge, and there is, in general, not an a priori answer to the question whether a trial will be fair or not. Potential prejudice may be rectified during the course of the trial, and the court may make preliminary rulings depending on how the case unfolds, and may revoke or amend them. Irregularis do not lead necessarily to a failure of justice. There is no such thing as perfect justice. A system where an accused person should be shown every scintilla of information that might be useful to his defense and discovery in criminal cases must always be a compromise. Fairness is not a one-way street conferring an unlimited right to an accused to demand the most favorable possible treatment, but also requires fairness to the public as represented by the state. This does not mean that an accused's rights should be subordinated to the public's interest in the protection or suppression of crime. However, the purpose of a fair trial provision is not to make it impractical to conduct a prosecution. I repeat. However, the purpose of a fair trial provision is not to make it impractical. It is not made to make it impracticable, which is stronger than impractical. It is not to make it impracticable to conduct a prosecution. The right The fair right does not mean a predilection for technical niceties and ingenious legal stratagems. To the contrary, courts should further be aware that a person, well, that talks about people who are charged with white-collar crimes. This is what 5 judges say, not me. It's not me. 5 judges. You haven't listened to this witness. You don't even know what he's going to say. You don't want to listen to that evidence. Okay, the law is clear. Egmont later, I have to hear and listen to you, even if you have those documents. I don't know how you're going to explain it. They also don't know. They must read the documents first. And you know what? If you don't understand him, go and consult an expert. Like I broke my back. You can ask the JP. 8 months, I gave you the right to consult an expert, ballistic expert. You have the right to do that. If it takes us 3 years, please do it. Go and get an analyst. Okay? No, I don't want to talk to you, sir. Please, I'm just telling you.
I wanted to make a submission regarding
What?
as to when we are coming back, my lord.
We're
My
coming
lord,
back on Monday. Okay, is that okay, Monday, Mr.? In the meantime, you've got to call a witness tomorrow, sir. Okay.
My lord, we don't have any witness line up for tomorrow.
And then Thursday?
Thursday it's it's a difficult day, but my understanding of my learned colleagues is that they just need time overnight that we can proceed tomorrow. That's my
But this
understanding.
witness is not available on Thursday.
Yeah, but tomorrow is Wednesday. We can proceed tomorrow.
Do what? Read the documents in his absence.
No. He's going to testify. It's Wednesday tomorrow. He is
No,
available.
Mr. Mnisi says he can't make head or tail of this document. It's not me saying that. He says that. Doesn't know what this document is here for.
No, I think the court misunderstood.
No, I did not, sir. I did not.
I never suggested that.
You didn't
we should-
suggest it.
As a result of that, we should therefore come back on.
No, that's never, you never suggested it. But you are saying these documents, 10 or 15 of them, you don't know what they're talking about. You are in the dark. That's it. So I'm giving you enough time. Wait. I'm giving you enough time until Monday to appraise yourself of these documents. And I'm saying, if necessary, go and consult an expert, analyst, concerning Section 22, downloaded documents.
Subject to the court's approval, can we make a suggestion that maybe we adjourn until tomorrow? See if they can wrap their heads around the document. And if needs be, perhaps we can adjourn until Monday, but let's adjourn
Yeah,
until
because this
tomorrow.
witness is going to write an affidavit.
Yes.
You've forgotten about that.
Oh, yes, yeah, that's
Please.
another.
Done and just finish off. I can do it tonight.
Have you finished that affidavit?
It's 90% finished.
Which you wrote it without listening to what you're supposed to explain.
That's correct.
Hello?
I said I listened to the radio.
Hello? Yeah, I'm telling you what I know about law. You haven't listened to the questions which he's going to ask you in clarification. But you already want to make an affidavit.
But my affidavit is just around the fact that
Yeah, fine, I understand it.
What?
I understand it. I understand.
okay,
But I'm just saying, you are told to write an affidavit on what?
to clarify the difference between a download and a Section 205.
And what else?
Because the way I understand it, the way Pinky put it in court, before court, it's nothing to do with a download because the download belongs to the police. And at this stage, I think they're all under the impression that I only work on one document. So I just want to make it clear to the
You work on
court.
several documents.
Yes,
Hello?
yes, I work on several.
Several documents. This system, you're going to explain it to me because I don't want to pretend knowledge. They call it the what? The Excel
Excel wide,
spreadsheet.
Yeah, the Excel spreadsheet.
Spreadsheet, how many documents do you use for that?
I use the section 205 of Vodacom, and I use the download.
That's
I do
it.
that too for.
Okay, so Monday, is it okay Monday, sir?
It's fine.
Yeah, Monday, so that nobody can complain of not having sufficient time. Okay, and then the affidavit, you'll bring it on Monday.
Yes, I can bring it tomorrow.
Okay, the court will adjourn until Monday.